Good morning, fellow Malaysians. This is Matthias Chang once again from Future Fast Forward. It's been quite some time since my last address to all of you. That's because in the course of the Chinese New Year, I was doing a lot of research on another issue. But came on 23rd of February 2018, I was totally disgusted with the judgment of the Court of Appeal on the 23rd of February 2018. What I would like to do is to highlight the key aspects of that judgment concerning one specific issue regarding the Prime Minister vis-a-vis the 1MDB. If I may now, please do me a favor. Before you watch this video, get your pen or pencil and a pad ready so you can take down notes and your handphone to photocopy the key documents. Alright? Because I've never ever in all my address promote fake news, propaganda, the way the regime is doing the ministers or the Prime Minister. My views are based on their utterance, their propaganda, their admission, confession, and actual documents. So now can you get your handphone ready and photograph this, okay? Alright? It's from the Sun Daily, 23rd February 2018. The picture of a judge of the Court of Appeal. Alright? Photograph this carefully. You got it? Okay. Now I'll read to you the key parts, alright? And I'll explain to you why I'm so disgusted with this judgment and the reaction of the leaders who have information to counter this horrendous judgment. The Court of Appeal ought to take judicial notice of the fact that the Attorney General has made a decision that Prime Minister Najib Razak had done nothing wrong in the 1MDB issue. This is reported by Sun that Datuk Sri Najib Abdul Razak, the Prime Minister, had done nothing wrong in the 1MDB issue. Okay? And then part of the judgment referred to, quoting the judge, he said investigations were also carried out by MACC, Royal Malaysian Police, Bank Negara, and the Attorney General's chambers, the result of which has been disclosed to the public by the Attorney General chambers that Najib had done no wrong in relation to the 1MDB allegation. Okay? This is the summary of the judgment on the issue related to 1MDB, alright, by the Court of Appeal, whereby the court ruled in favor of Najib in his personal action against Tony Phua, MP of Parliament, Member of Parliament from DAP. Now the key word is, and I repeat again, Prime Minister Datuk Sri Najib Abdul Razak had done nothing wrong in the 1MDB issue. Alright? Incredible, isn't it? And he said he's taken judicial notice of the investigations by MACC, the police, AG, PAC, and what have you. Right? And he said, by virtue of the court taking judicial notice, right? This was happened. In his judgment, Jacob said that Section 56 of the Evidence Act 1950 provided a legislative window to which a court may decide to judicially take notice of a fact or matter for which no further proof needed to be adduced to establish its evidence. Meaning, the court is saying, because there are some other investigations conducted by institutions like the MACC, police investigation and their findings, the Court of Appeal will take those findings, all right, take notice of those findings without further need of those findings to be adduced in court as evidence. That means the court, this judge, being aware of all these facts in the public domain, has taken notice of those facts, the findings, and deemed it sufficient to decide on the matter before him in court without further evidence. Now he quoted Bank Negara, okay? Right? Now if he said he has taken notice of Bank Negara, I wonder whether the judge, the three judges Court of Appeal, and whether the plaintiff's lawyers may have misled the court. Because if the court has taken judicial notice, they would be aware of a public statement by the former Bank Negara governor, Tan Sri Zeti, right, published on the 24th of June 2017. This is what it says, right? Bank Negara, Malaysia was powerless to take further action than just some fines to relevant bodies and financial institutions over breach of regulations in relation to one MDB case. And it was admitted by Tan Sri Zeti that the handling of the one MDB case was one of the toughest moments in office. Now, this is important. Although outsiders had very high expectations from Bank Negara, nevertheless, it did not have the power to prosecute. Bear that in mind. It did not have the power to prosecute because the AG has the power to prosecute. Bank Negara has the most comprehensive laws, including the Central Bank of Malaysia Act 2009, the Financial Services Act 2013, to preserve the integrity, stability, and healthy functioning of the financial system. Now, next part is very important. The words by Zeti. So we could issue letters of administrative compound to relevant bodies and financial institutions breaching Bank Negara's regulations in the 1MDB case. I would say the fines excuse me, were probably the highest in history. She added that the primary objective of BNM in dealing with the 1MDB case was to ensure the integrity of the country's financial system. In March last year, Bank Negara said it would initiate appropriate action against 1MDB for failing to produce evidence and used to allocate US 1.83 billion for debt management and restructuring access overseas. 1MDB had initially cited these two reasons when asked why the money had not been repatriated to Malaysian shores. Now, the Court of Appeal must have deemed to have notice of these facts, right? As told by none other than the governor of Bank Negara. That goes to say, Bank Negara then fined 1MDB on April 28 last year, given the state-owned investment fund a May 30th deadline to settle the fund. 1MDB paid a fine on May 25th. And with that, new Bank Negara Governor Mohammed Ibrahim said the Central Bank's investigation into 1MDB has concluded. Next paragraph is very important by Tan Sri Zeti. We knew Bank Negara was a very important to the country. Court of Appeal, alright? Read the sentence again. We knew Bank Negara was very important to the country. We didn't want to see it destroyed. And that was one of our main considerations. So, 1MDB would have destroyed the reputation of Bank Negara and the financial institution. That was how serious Bank Negara took the issue of MDB. We didn't want to see it destroyed, Bank Negara. That could be the effect if there was no proper resolution to 1MDB. Okay? So, this is Sun Daily about a statement issued by Tashi Zeti, the former governor of Bank Negara. Alright? And this is 24th June. Okay? 24th June 2017. Way before the court appeal hearing and decision. And since the court said they have taken judicial notice, how can they say that Najib has done nothing wrong regard to 1MDB? Now, listen to this. Criminal offence has been committed by 1MDB and each and every member of the board of directors and officers of 1MDB, but particularly by the Prime Minister come Finance Minister, because he has the sole authority under the Memorandum Articles of Association of 1MDB to decide on policies and all financial matters. And he was a sole shareholder. Okay? So here, in 215, okay, 3rd June 215, Bank Negara issued a press statement. Right? Please go to Bank Negara's website. Okay, June 215, 3rd June. Let me read to you highlights. The purpose of this statement, press statement, is to provide clarity on the role of the central bank with respect to any resident entity, including 1MDB, that makes investment abroad or obtains offshore borrowings under Section 214 of the Financial Services Act 213 and under the Exchange Control Act 1953 that was enforced prior to 213. All investments that exceed 15 million ringgit per calendar year and any offshore borrowings that exceed 100 million ringgit by resident entities require the central bank's approval. That means 1MDB must get Bank Negara's approval for their nonsense with Petro Saudi and ABA, okay, and IPIC. In relation to all this, submissions that were made by 1MDB have had to comply with the same approval criteria that is applied to submissions by other business entities. No exception. Even though 1MDB is owned by the government, they must go through the approval procedure. If criteria is not met, the submission will be rejected. No leniency or special exceptions were accorded to 1MDB. Now, there will be triggers for investigation if there is non-compliance by any entities, including 1MDB. When monies for which approval are given are not used for the purpose indicated in the submission. When incorrect or false information are provided in the submission. Failure to comply with the conditions in the approval. Okay? And under the Financial Services Act 213, non-compliance of those three criteria, a penalty for failure to meet this request can result in a fine up to 15 million or 10 years in prison or both. Photograph this page. Part of the press statement which I've enlarged for your convenience. Okay? 3 non-compliance will mean fine up to 50 million or jail for 10 years or both. So, did a judge or the judges of the Court of Appeal take notice of this fact? The press statement of Bank Negara. Okay? And then, Bank Negara issued another press statement, 28th April 26. Photograph this. the actual press statement with the logo of Bank Negara. Okay? I'll read to you the contents. Okay. Now, let me read to you. This is very important. Following the receipt of the consent of the Attorney General today. Okay? Alright? Bank Negara, 28th April. Bank Negara Malaysia has issued a letter of administrative compound to 1MDB. Under the Act, Bank Negara can only issue a fine with the consent of one of Attorney General. So how can a court of appeal say the Attorney General has exonerated Najib of all wrongdoing excuse me, with regard to 1MDB? He may have exempted him on a donation to his personal account. But to say that statement on a 2.6 billion into his personal account, exonerate all other crimes by the Prime Minister with regard to 1MDB is totally wrong, rubbish, and a grave injustice to the people of Malaysia. Alright? It's a grave dereliction of duty. Having said that he will take judicial notice, then did the court take notice of this fact? Because he said it. Alright? There's no requirement of the lawyers to even present these facts, because the court is deemed to have notice. And what he says here, Bank Negara, 28th April, for failure to comply with the directions issued under the Financial Services Act. This includes the requirement for 1MDB to repatriate monies remitted abroad following the revocation of 3 permissions granted by Bank Negara Malaysia to 1MDB in 2009, 210, 211. The 1MDB has also failed to submit evidence and documentation specified by the bank to justify its inability to fully comply with the repatriation order. 1MDB has been given until 30th July to pay the compound. So the court must take judicial notice. It was given a ruling and direction by Bank Negara. No further evidence is required to prove wrongdoing by 1MDB, which at that time was under the sole control of the Prime Minister. Failure to comply with the directions issued by Bank Negara under the Financial Services Act is a crime. Failure to repatriate monies sent abroad, bring back the money from abroad, right? Following the revocation of 3 permissions granted in 2009, 210, 211. Meaning, those permission application for approval was dishonest, misleading, or even false. That's why Bank Negara cancelled the approval retrospectively. In 2009, 210, 211, Bank Negara approved after being misled and those transactions were genuine. Later, when they found it was fraudulent, those approvals have been revoked, understand? Cancelled, my dear lords of the Court of Appeal. And once an agreement, contract, applications, approvals are cancelled, all the agreements, transactions, dealings are deemed unlawful, my lords of the Court of Appeal. Under the Contracts Act, it is void. If a contract is void, it's unlawful, a crime has been committed. So have you taken judicial notice of the provisions of the Contracts Act? And this statement by Bank Negara, if I may, at this point, tell all my Malaysians that this judge, this Court of Appeal, take notice of the Federal Court case between Tan Chi Ho, and court focus decision berhad. Citation 214 3MLJ page 301. Judgment delivered on the 4th of March 214. It says here, judgment of federal court delivered by none other than Ralph Sharif, then the Presidential Court of Appeal, now the Chief Justice. It is perfectly settled that when a contract which the plaintiff seeks to enforce, be it express or implied, is expressly or by implication forbidden by the common law or statute, no court will let its existence to keep effect. Bank Negara has revoked the approvals under the statute, not common law, Foreign Service Act, for being fraudulent, non-compliant. It's unlawful. Court will not enforce it. Therefore, the Court of Appeal must take notice of that. The Court of Appeal cannot say Najib has done no wrong. It seems clear that the underlying principle or policy is one of deterrence, that the courts will not encourage illegal acts by allowing the claim based on them. So Najib has claimed in court, I've done nothing wrong. Therefore, Tony Pua is incorrect to criticize me. And the court took judicial notice because AG says 2.6 billion is not a crime. But how about other crimes identified by Bank Negara? And this federal court says, if that's the case, the court cannot lend credence to this transaction. And then the federal court quoted Section 66 of the Contracts Act. Court of Appeal, open your eyes and open your ears, if I remind you. The effect of a void contract or agreement is provided under Section 66 of the Contracts Act 1950, which reads, quote, when an agreement is discovered to be void, or when a contract becomes void, any person who has received any advantage under the agreement or contract is bound to restore it, to make compensation for it to the person whom he received it. An agreement, therefore, discovered to be void is one discovered to be not enforced by law, and on the language of the section would include an agreement that was void in the sense from inception as distinct from a contract that becomes void. Okay? And the federal court quoted the Privy Council case of Harth Court against Indus Singh, 1922, law reports 1950. Sorry, one law reports 50. And then also quoted another Privy Council case in the case of Malacca versus Lam Kam Chun, 1977, 1 MLJ 91. So, once Bank Negara has revoked the approvals, the contract is void ab initio. Crimes may be committed under the 3 triggers by Bank Negara. Okay? And the 3 triggers are what? Where the monies were given were not used for the purpose stated in the submission of approval. When incorrect or false information are provided to the Bank Negara for submission. Failure to comply with the conditions of the approval. Okay? These are, okay, the contravention by Bank Negara. Sorry, by 1MDB. Alright? And there's a court case upholding the effect of void contracts. Unlawful. So if you are committing something unlawful, are you free from all wrongdoing? Your words, Court of Appeal. Najib is free from all wrongdoing in the 1MDB. And because of what, of also the report by PAC, delivered in April 2016, Let me say here now, Tai Seng Kiao, you are a traitor to the Malaysian people. The PC report is a cover-up because you ought to know what was going on by Bank Negara in the investigation. And you cover up, and you talk rubbish. I challenge you, Tai Seng Kiao. You said in the absence of the chairman, you took the helm and declared Najib has done nothing wrong, and that's why the court took judicial notice of your whitewashing. PAC. Shame on you, shame on you, shame on you, Tai Seng Kiao. Okay? Why have you not took that into account in the PAC report? Why have you not taken account the provisions of the Financial Services Act 213 and how they were contravened? Now, after the fine imposed by Bank Negara on the 28th of April, with a deadline on the 30th of May to pay up, 1MDB on the 25th of May 2016 paid up the fine. Alright, as quoted by NST Online, may I read to you. One Malaysian Development Berhad today announced that it has made full payment of a fine imposed on it by the central bank. One MB confirms that today make payment in full of the compound in compliance with the Digit 01 of Bank Negara Malaysia. So, fine was imposed. Fine paid. What does it mean? Court of Appeal? What does it mean? Attorney General? What does it mean? Counsel of the Plaintiff? Prime Minister in the hearing of the Court of Appeal? It means mengaku salah. You pay the fine is an admission of guilt, and the fine can only be imposed with the consent of the Attorney General. When the Attorney General consent to this fine for contravention of Financial Services Act, so critical it can destroy Bank Negara's reputation and the financial services of Malaysia, that means Attorney General agreed crime has been committed, wrong has been done. Don't use one statement about 2.6 billion in the personal account of PM, which he denied, so-called denied, paid by the Arab, as a total blanket exoneration of all his crimes, his sins. This is the most disgusting Court of Appeal. And you say you took judicial notice? Can you pick and choose what you want to notice and what you ignore to take notice? Let me say to you, Court of Appeal, Attorney General, and the lawyer for PM in the court case with Tony Puang. Okay, read this. Section 249. Okay, 1B. Who is concerned when an offence is committed by a body corporate? It was on MDB, a person who is concerned in the management of his affairs at the time of the commission of the offence is deemed to have committed the offence. Understand, judge? In a corporation like 1MDB, a person who is concerned with the management of the affairs at the time of the commission is deemed to have committed that offence, unless the person proves that the offence was committed without his consent or connivance, that he exercised such diligence to prevent the commission of the offence as he ought to have exercised, having regard to the nature of his function in that capacity and to the circumstances. While the Prime Minister had controlled the company, he has not given any excuse for the non-compliance. He was aware. Okay? And any individual may be prosecuted for an offence under subsection 1, notwithstanding the body corporate, 1MDB, has not been convicted of the offence, whether or not a prosecution has been initiated or a conviction has been obtained against the body corporate. Subsection 1 shall not affect the criminal liability of the body corporate or incorporated for the offences related to that subsection. You see that? You see that? So how can you say Najib is not involved? He has committed offence under the Financial Services Act. Okay? Now, Section 250, where a person is liable under this Act to a penalty for any act, omission, neglect, or default. Such a person shall be liable for the same penalty for the act, omission, neglect, or default of his employee, director, controller, or agent if the act, omission, neglect, or default was committed by A. His employee in the course of his employee's employment, Jasmine Lu, Casey Tang, what have you. His director in carrying out the function of the director, or the board of directors who committed a wrong. His controller or in carrying out the function of a controller. His agent may take on his behalf. So, who's the head honcho? What MB? The Prime Minister, come Finance Minister. Who committed crimes? Right? All the underlings acting with the China Kwai, bastard, what Jolo, the chief money launderer. The board of directors were also involved either by active participation or by omission. It doesn't matter. If a crime is committed, the person in charge shall be liable as well. Have you taken judicial notice of this provision? Now, 253 about compound. This is what happens. So don't say AG has exonerated PM. The governor of Negara, the governor may, with the consent in writing of the public prosecutor, Miss AG, offer in writing to compound any offence punishable under this Act or any regulations made under this Act by accepting from the person originally suspected of having committed the offence such sum of money not exceeding amount of the maximum fine to which that person would have been liable if he had been convicted of the offence within such time as may be specified in the offer. An offer under subsection 1 may be made any time after the offence has been committed, but before any prosecution for it has been instituted. Okay? So here you are. A fine can only be imposed after offence has been committed. Have you taken judicial notice of this fact? And it must be the consent of the AG. So AG make a finding. Offence has been committed 1 MDB. By employees 1 MDB. By everyone involved at 1 MDB. And Bank Negara can have a choice to impose the fine on the company or on individual. Okay? And by payment of the fine on the 25th of May 216, what does it mean? It's not the Prime Minister involved in wrongdoing. So, what do you have to say? What do you have to say? My dear Judge of the Court of Appeal, you make reference to the police investigation. Okay? Now, you may forgot that Attorney General on 16 June last year make a statement. No evidence money has been misappropriated from 1 MDB, says AG. Muhammad apparently said 1 MDB was a Malaysian company and had been the subject of multiple investigations within Malaysia, including the Malaysian Anti-Corruption Agency, a commission, Auditor General, and Bipartisan Public Accounts Committee. After review, we found that no crime was committed. Presently, there's still an ongoing investigation conducted by the Royal Malaysian Police concerning 1 MDB. So, he made a statement no crimes committed, in total ignorance or pretend to be ignorant of Bank Negara investigation, for which he gave his consent. Can you see? Can you see the difference? The contradiction. In 216, he consented and agreed offence was committed by MDB. Fine was imposed. And now he says there is no, there is nothing wrong. No crime has been committed. Then why did he give the consent? To fine to be imposed on what MDB. And then, fair enough, the former IGP made a statement. After the statement made by AG, the Inspector General of the Police today revealed that police have completed its probe into what Malaysian Development Berhad and have submitted the investigation papers to the Attorney General Chambers. Tan Sri Khalid said police have completed the investigation some time ago. He was commenting on Attorney General Tan Sri Muhammad Appandi's orders for the Malaysian Anti-Corruption Agency to wrap up their probe on former 1MDB subsidiary SRC International. April 2017. The police, all this while, were investigating. Alright? They submitted to AG. What did AG do with it? Nothing. They asked the police to submit and investigate SRC. So how can the Court of Appeal says that the police investigation has resulted in no wrongdoing? No. AG cannot say that because AG asked them to investigate further. Okay? And then on June of 2017, all right, Free Malaysia Today, this is what the IGP says. Khalid Abu Bakar, the former IGP. Inspector General of Police Khalid Abu Bakar has declined to disclose why the Attorney General's Chambers sent back the police investigation report on state-owned 1MDB. I'm not going to disclose the information, he replied, when asked what the AG wanted to be probed further. When pressed further, Khalid said he would comment on the matter once the investigation is completed. Khalid on 25th June told reporters that AG Chambers has directed the police to investigate the 1MDB issue further, which they are now doing. So, was there a blanket exoneration of the Prime Minister when police investigation is still pending? And then, out of the blues, in October 23rd, 2017, when police investigation is still pending, the Deputy Prime Minister issued a statement. Local probe into 1MDB long ended, not relevant for the debate in Parliament. Okay? How can he say that when AG has demanded further investigation? Then, on October 30th, 2007, the de facto law minister, Azalina, was going to say, in a written parliamentary reply to Gobind Singh Dio, Azalina said instructions were given on October 24th. As the investigation is still ongoing, any revelations about the details can affect and prejudice the ongoing probe. And then, on 1st November 2017, okay, police received 1MDB papers with fresh AG instructions, says Deputy IGP. Deputy Inspector General of Police, Noor Rashid Ibrahim, says the police have received investigative papers on 1st on 1 Malaysia Berhad, with instructions to reopen the case. Yesterday, AG Ahmad Pandi Ali said he ordered police to reopen the probe after the AG chambers found that there were insufficient evidence. So, there is a continuation investigation of 1MDB. So how can the Court of Appeal says he's exonerated? On 2 grounds he can't say that. One, the police says there's ongoing investigation. 2, more importantly, way back, AG has consented to the fine imposed because offence has been committed under the Financial Services Act. All the transactions in 2009, 2010, 2011 were illegal void by virtue of the revocation of the approvals by Bank Negara. See, what I don't understand is this. I've been saying this for quite some time now, isn't it? In my previous videos. Yet, the leaders, I don't know why, no leaders to take it up further. So are you surprised, or should I be surprised, that the court chose to turn the eye away from this fact? The lawyer, MP from PKR, William Leong, sat on the PAC. He's a lawyer. He can't say he's ignorant of the law or the facts. Alright? You sit on PAC. Alright? And PAC is an instrument, a cover-up, led by Tan Seng Kiam. Some of you have read the English translation. I won't go into this. It's disgusting. The conclusion, right, of the PAC is that, right, there was some mismanagement, oversight, wrong corporate management principles based on boring what have you. When it was from day one fraudulent contravention of the Financial Services Act and the Directive Bank Negara. Is that mismanagement? Tan Seng Kiam, you numbskull? Is that mismanagement? Every member of PAC? All crimes committed by the Prime Minister come Finance Minister. Now, more importantly, we have noticed a lot of legal actions in filed in court against the Prime Minister for various causes of declaration and remedies. Why not one application by the opposition parties to declare that the Prime Minister is disqualified to stand for election because the fine imposed on 1MDB, right, is huge, over 2,000. And let me repeat again. Najib is a sole responsibility, has sole responsibility over MDB. And under the Financial Services Act, any offence committed by his employees or by board of directors, Prime Minister Najib is responsible and liable under the Act. So when he paid the fine, alright, and agreed to pay the fine on behalf of 1MDB, he's guilty. Right? And as the law is very clear, on this point. Okay. That if and when a company, right, was incorporated and the activities of the company is fraudulent, the people behind the company are liable. Under the principles of, right, incorporation of a company, generally, shareholders are not liable for the acts of the company. Alright? This is called a legal concept. A corporate body has a corporate personality. Under the famous case, House of Lords, Solomon and Solomon. But over the years in England, if fraud has been committed, crimes have been committed, then a court will lift the veil of incorporation and go behind and see who is the scoundrel, the scumbags, the criminals who control the company and using the company as a vehicle. That's what happened, isn't it? Various companies are incorporated all over the world under tax havens. By Joe Low, with the knowledge and consent of 1MDB, with the knowledge and consent of the Prime Minister, set up a bank accounts to launder money. The biggest money laundering case in history. Okay? There are two cases which shows that you can go behind the veil of incorporation and go after the scumbags criminals. The first is Guildford Motor Company against Horn, Jones against Lippman. And I challenge any lawyer in town, especially lawyers in the opposition parties, for not taking up this issue before the court. Since they are so happy to take issues before the court, why of all the issues you people chose to ignore the jugular issue? The Prime Minister has committed a crime, fined, but you kept quiet, you see, as if you don't know about the principle of piercing the veil of incorporation. Let me quote to you a paragraph in the Household's case of Solomon against Solomon. Has remarked the principle of lifting the veil of incorporation, properly applied, the principle that it is appropriate to pierce the corporate veil only where special circumstances exist, indicating that it's a mere facade concealing the true facts. In the figurative sense of facade, it denotes outward appearance, as if one that is false or deceptive and imports pretense and concealment. 1MDB was from beginning fraudulent, a vehicle for money laundering, to enrich Joe Low, the regime of Najib, and the money went around the world and came back to his personal account. And then the court said that there are three components as to when we can go behind the company and go after the criminals. If you can prove. And now, why should a court of appeal take judicial notice? Because the Prime Minister admitted he's taken the money into his personal account. There is a case in America led by the DOJ. All the pleas are before in public domain. There have been prosecution of various bankers in Singapore implicating 1MDB and the Prime Minister. So, the three components of factors that will allow a court to lift the veil of incorporation is this: control and domination. Control and determination part test determines the relationship between the shareholder and the corporation. One must show complete dominion, not only of finances, but of policy and business practice in respect of the transaction attacked, so that the corporate entity as to this transaction has no separate mind, will, or existence of its own. That means, although a company has a separate corporate personality, if the person who's in control, Najib, controls the finances, the policy, the mind of the company, then you can lift the veil. Okay? Because all companies must act through individuals, the board of directors, right? But if one individual's dominions, control, is so strong, over everything, and as crimes been committed, money laundered, then the court will lift the veil of corporation. Second, improper purpose or use. The test requires that the plaintiff, we the people of Malaysia, to show that the control exercised by the parent company or dominant shareholder was used by them to commit fraud or wrong, to perpetrate the violation of a statutory or other positive legal duty, or dishonest or unjust act in contravention of our rights. You see? Then Negara said, 1MDB, the officers have all contravened the provisions of the Act, have committed offences, and they can only impose a fine after the offence has been committed. Third, harm and damage has resulted. The Malaysian people, the taxpayers, have suffered harm, not only financially but also reputation-wise. Okay? Reputation-wise. Now, you dare tell me, Judge of the Court of Appeal, that you have taken notice there's no evidence whatsoever of wrongdoing? Heaps of evidence before you. You chose not to take due notice of all these facts I give to you, except 2 words, or 2 sentences, or 2 statements from the Attorney General. It's a donation to 6 billion, and a statement that no crime has been committed. In 2007, his statement, which is abuse and contradiction of his statement, his consent given in 2016. This is disgusting. Therefore, I appeal to all Malaysians across the political divide, and I appeal to you, do not vote for any candidates for this coming election if there's one, whether for Barisan Nasional or for the opposition PakatanHarapan. None! Especially lawyers who are candidates. Ask them and demand from them why they have not explained to you what is the effect of the fine paid by 1MDB pursuant to the order by Bank Negara. Ask and explain to you, right, the provision of 255, section 255. Why they have not the guts and the balls to ask for a declaration that Najib Razak is not fit, not qualified to serve for election. If they're attacking Anwar, there's not qualified person in prison, and Anwar says it's a political crime, it's fixed. But in the case of Najib, he admits on everything. He admits to the wrong. And the fact is they paid. Why have they not? They've gone to court so many times, right? Filed so many action. Why can't they file this action? On behalf of the Malaysian people. We as individual riot, we may have the resources. The party, every one of them in PakatanHarapan. And if you are the honest MP in Barisan Nasional, you want to be safe from God's wrath, you demand answer. You demand that Najib step down and face the music. Otherwise, this so-called election is a charade, a farce. If the candidates in their charamas, both Barisan Nasional and PakatanHarapan, don't have the guts to address this issue, why not go for the jugular? They're already hammering you, PakatanHarapan. Having passed, have not allowed registration of your PakatanHarapan and your parties, what have you, right? All the hurdles thrown against you. And you guys meekly protest, but the jugular, the weapon that will sink Najib as a leader, as a person, you do not touch it. You shy away. And I've been saying this for the last 2 years. You might say, you freaking candidates, you freaking MPs, why don't Matthias file the action? Why should I? I've done enough. Bank Negara said 1MDB has almost destroyed Bank Negara. Integrity and reputation. And yet I was accused under SOSMA to attempt to sabotage the banking and financial services of Malaysia by reporting a crime, assisting my client to report in overseas jurisdiction. I've done my part. My family has sacrificed enough. Now it's your part, because you want, and you display to the whole country, you want to be elected, right? You want to have power. You want to destroy the scumbag Barisan Nasional. Then show to us. Every candidate of Barisan Nasional, for PakatanHarapan, you have the balls. Otherwise, you're a hypocrite. Yes, this is a very hard criticism. It might change people's votes or minds. That's not up to me to decide, it's for God to decide. But don't come and tell court a bull. Okay? I spare no criticism if I see wrong. I've consistently condemned and exposed the wrongdoings of the present national government, the regime, and the fascist regime of Rajim Rasad. The kleptocrats. Doesn't mean you can get away with it, right? And go to high pedestal. I will judge you, PakatanHarapan, on the same standards as I will judge Present National. And God may one day choose to do otherwise and unleash the cleansing fire so this country will learn a lesson. We have a duty to expose truth, expose the hypocrisy and the crimes of the people. PAC has totally betrayed the trust of the Malaysian people, especially the traitor Tan Sing Kiao. Okay? Exonerated Najib when the crime is so clear. When the bank Negara has give out crystal terms what they've done wrong. The whole transactions 2009, 2010, 2010, 2011 are all illegal. It is unlawful. That's it. And you still beat around the bush? Huh? Create diversion? Why? Bar council, the lawyers. Why file action to say the appointment of the Chief Justice or the Penal Court Appeal is unconstitutional? That's a diversion. Irrelevant. When the head of the snake, the vulture, the crime syndicate is exposed to crime, you, the so-called legal eagles, talk and talk, no action, but divert on the irrelevant issue. This judge in the Court of Appeal, right, has done more harm by that one judgment. Najib has done no wrong. Thinking we are all blind. We are stupid. Well, we are not stupid. The right not stupid. You, political leaders, you have betrayed our trust. All of you. It's sickening. You know? So I hope. I only want hope actually. I've told many people all this. And I pray every morning. Because I believe truth will prevail. And God, Allah said that you under the Quran, you can invoke the curse of God Almighty, Allah, on those who betray truth and tell lies. So if you people keep on betraying the truth and tell lies and mislead, God has allowed us to invoke His curse on you. Okay? That's what I'm doing today. Not so many words. So let me say to all of you fellow Malaysians, let's not promote the myth of democracy. But there's no democracy at all in this country. It's a sham. Either we fight courageously and expose all the lies and shit and crimes. That's better if Allah comes down with cleansing fire, cleanse all the shit, the garbage, the hypocrisy in our country. I would like to conclude once again, my dear fellow Malaysians. I'm not frustrated. Yes, I'm angry. But my faith is absolute. Because only one victory, as I'm concerned. The ultimate victory is truth. The absolute truth, the eternal truth. That He will prevail. Justice will prevail. God will prevail. And the only thing that keeps me going, and I hope you will keep me going, is surrender to the will of Allah. Completely. Have absolute faith that He will protect us defend us and guide us under all circumstances, in the face of all enemies, adversities, challenges, vouchers, hypocrites, freaking assholes who pretend to be somebody when they are not, and evil that's before you, before your eyes. Pray to Allah, destroy this evil, and let's be delivered to Him in eternal peace and happiness. With that, I thank you for your time, and I hope you spread this video far and wide. Thank you.